بسم الله الرحمن الرحيم نحمده ونصلي على رسوله الكريم أما بعد. Previously we discussed the conditions of contract. Overall there are two types of conditions, which is shurutul bay' and yes, we discussed the conditions that imposed by law, by Sharia. We talked about 5 types of conditions which are imposed by Sharia. We talked about shurutul inqad, concluding the contract, shurutul sihha, validity of contract, shurutul nifaz, the execution of contract, and shurutul luzum, the contract to be binding. So I think 4 types of conditions that imposed by Sharia we were discussing. And the most important thing, we discussed the relation in between all these 4, right? So that is most important to easily remember the conditions, because the first one starting from the concluding the contract. Then the next one is the validating the contract, then the executing the contract. Then once everything finished, then you have the binding of the contract. So I think I hope you got the relations between all these 4. Now we are moving into the second type of second type of condition, which is the conditions that stipulated by parties. So now it is not about what has been already there by the Sharia, the conditions that made by the Sharia. This is actually the conditions that, what about you and me? Can I make any conditions other than the 3 pillars of contract? Because whatever the basic thing has to happen, it is already there, because Sharia already stipulated. So now my question is, can I add any conditions to that? Can I say, for example, if I am ready to sell my refrigerator to you, but the condition that I cannot deliver to you, right? Or you might asking somebody to sell his TV and then say, I am ready to buy your TV, but the condition is you should come and deliver to my home, right? So these kind of additional conditions, let's say you said, okay, I am ready to buy some computers accessories, but the condition is you should come to my place and you should assemble those accessories. Yeah. Let's say I am ready to buy a bicycles, but today you can see bicycles can come into many parts. Maybe you are not the expert in assembling those parts together so that you can create the bicycle on your own. So perhaps you might need some sort of expertise. So you said, okay, I am ready to pay this amount, but the condition is you should come to my place and fix it, right? Whether it is accessories with regard to Wi-Fi connections, or with regard to telephone connections, or other than these, anything like kitcheneries, kitchenwares, anything like, for example, groceries. I'm ready to buy a bunch of groceries from your shop, but these are the conditions, right? So these kind of conditions, like for example, you and me, we are actually we are creating these kind of conditions. So what do you think? Do you think until what extent that these conditions are valid? till what extent that these conditions are void. So which one is allowed in fiqh al-muamalat and which one is not allowed? Perhaps, I mean, in fact, if it is not allowed in Sharia, which means that it is also not good for the humanity, because the maqasid of Sharia is actually bringing the maslaha, bringing the harmony, maslaha to everybody. So the reason why Allah, this is this is the point we always keep in mind when we discuss anything related to fiqh al-muamalat. You should always keep that in mind. The reason that we learn all these usul, the issues, the matters arising within this spectrum. The reason why, because the Sharia always wants to aims to benefits of the society, right? You see, if Sharia said these transactions are prohibited, it doesn't mean that it is only prohibited because Allah and Rasul said. It is prohibited because most of the transactions that related to human being, we are not actually doing any transactions to to Allah, right? Of course there is a different kind of transaction. When Allah said, inna Allah ishtara min al-mu'minina anfusahum wa amwalahum bi anna lahumul jannah. Yes, Allah used the word ishtara because he bought our soul and our wealth in return that he can actually give us the paradise, Jannah. So that one is actually a philosophical view of transactions. Of course, we agree. Other than that, when we do a transaction in this world, okay, that one is for the akhirah. In this world, when you are doing any transaction, it is actually you are doing to any human being, whether it is a Muslim or non-Muslim, right? Whether it is your friend or your husband, your spouse, your wife, right? Or your children or your neighbor, anybody. It's a human being transactions. So when Sharia said this kind of transaction it is not allowed, definitely the reason is either one of you is suffering. Other than that, Sharia has no interest in stopping your transaction, although you have benefits. If you have benefits, for sure, Sharia is not going to stop you to do that. The reason Sharia is prohibiting such things because either one of you may have a trouble, right? For example, why Sharia said riba is haram? Because one of you is gaining, the other one is not gaining, the other one is losing. And then the core values, that what we call today, the core values, the benefits of the exchange, it's actually missing. When you see the transaction of interest, the usuri, one party is actually gaining from the transaction, which is the money is becoming commodity, and there is a end mean. So now the money has become end mean. What I mean by that, it's supposed to be the medium of end, but here it's becoming the end. So meaning to say that using the money you are supposed to do exchange, right? So money is a medium of exchange. So you have money, you buy this, you buy that, so you use the money as the indicator, so you are buying it. But when money is becoming the commodity, then it becomes the end, right? So when it becomes the end, so of course, obviously only one of the party is actually gaining, the other party is losing, even though you may think, no, when I get a loan, when I get money out of interest, it is actually I'm also getting some benefits. You may have these kind of questions, that I am also having some benefits when I apply for interest, when I apply for loan. The truth is that benefit is something that going to give you some other benefit, meaning to say that when you are trading, you are actually doing business. Let's say you use the money and then you buy something and then you use that thing to buy something else, right? It is not the consumption, it is the dealing, it is the transactions, right? But remember, when you are consuming, consumption, for example, I have to eat, I have to live, I have to use a transportation, it is called consumption. So when you are consuming something, it is, of course, we learn all these things. It is called what kind of property? It is called it is a perishing property, meaning to say that it will perish. It is not going to be, it is not going to be useful, or it is not going to be there forever. It is going to be perish. So now your consumption is actually kind of perishing, and you are not going to get it back. Let's say I spend 100 ringgit, and then sorry, I borrow 100 ringgit, and then I wanted to eat, but in return you have to pay 120 ringgit. So this additional 20 ringgit, from where actually you are paying? You are not using that 100 ringgit for business. So here we are talking about consumption, not the not the not the transaction. Yeah, we are not talking about the business dealings that we are talking about. Here we are talking about you eat and you have to pay 120 ringgit now. So now you are not paying exactly what you took from as a loan, but you are paying extra 20 ringgit. For that extra 20 ringgit, you have to get that 20 ringgit from some other dealing, which is actually difficult for you. So for this reason, Sharia is prohibiting this kind of riba transaction. So now clearly, you see the entire Fiqh al-Muamalat. Whatever so far we learned, that Sharia is prohibiting this kind of conditions, prohibiting this kind of purposes and effect, prohibiting this kind of classification. We will be discussing later after this. So every single thing is for the purpose of bringing the benefits to the human society, right? There's nothing else. Allah doesn't want us to just listen amanna wa sallamna. Allah has so many maqasid for every single thing that we are doing. There are the secrets of hukum. Why Allah asks us to do fasting, why Allah asks us to do praying, why Allah asks us to pay zakat. There are there are quite number of maqasid. There is a purposes, benefits. So now when Sharia is saying that this kind of conditions is wrong, it means that of course it is actually quite benefiting for you and me, right? So okay, so we are here discussing the conditions that you and me can create. So what kind of conditions that you and me can create, what kind of conditions that you and me cannot create. This is what actually we are going to learn, and the reason we are learning, because we want to benefit the humanity, right? Okay, the conditions stipulated by the parties are free to choose any kind of or any particular form of contract. However, once concluded, they are not free to change or add new effects to a contract. The effects and consequences for each individual contract are already determined by Sharia. These effects and consequences result and apply automatically. Right? You see, yeah, we talked about the purpose in contract. I mean the sale. What is the purpose in renting? What is the purpose in being in becoming the guarantor? What is the purpose in leasing, right? And then there is also effect. We talked about what is the effect in sale, what is the effect in renting, what is the effect in leasing, what is the effect in becoming the guarantor. So for each, and like we talked about, of course, contract, sale, we talked about ijara, i'ara, kafala, hawala, this kind of, there are so many other kind of contracts also upcoming. So we will be discussing, especially when you go and learn the next semester, which is Fiqh 2. I think you will be learning more types of contract as well, right? So here it is. Now, based on the purposes and effects that Sharia already decided, so those are the things already determined by the Sharia. Those are the things cannot be changed. As long as you are not changing that kind of purpose and effect, then any particular form of contract you are doing, it is allowed. You see, when the Fiqh al-Muamalat talk about the sale, of course, they were talking about the sale of their time. uh, that one was a barter exchange. Then they go to market, and then they talk about the market mechanism, and then how the things been moving around and everything. And then they talk about the farming, they talk about carpenting, right? But today, the time changes, and then you can see that there are so many varieties of contracts are available. And now, in fact, we are sitting at home and doing so many kind of contracts, which I call it online transactions, right? So we can actually buy anything online, we can get services online, and people can come to your doorstep and deliver to you the items that you need the most. So of course, the basic things are there. These are the new particular forms. As long as you are not changing, we are not changing the purpose and effect, I think all kind of these kind of transactions, there is no harm in Islam, in Sharia. This is what the first part of the slides actually trying to tell you. Then, however, the parties may add conditions to this kind of contract. They can add any condition that are harmonious with the nature of a contract. Remember the harmonious nature. This is very important. Other than these conditions, like what I told you, for example, if you are him requiring, if your seller is requiring a down payment, this is the harmonious kind of conditions, right? For example, you want to conclude a contract of buying a land, or you want to conclude a contract of buying a car or house. So there is no harm, even though the car is not completely built, the land is not completely ready to move, I mean ready to be given, the house is not completely finished, so the door, the key is not still given. Still, if there is a requirement of down payment, there's nothing wrong in it, because a seller may require of the buyer a down payment, right? A seller may require um, uh, 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 a seller may yeah, a seller may require buyer a down payment in return for a stated delay in the payment of the price of the goods. Yeah, so this kind of, we call it a booking. If you want to do the booking, it is actually possible to do so according to the view of majority of scholars. Conditions put by, yeah, this is the next one. So now anything if it is harmonious, for example, you go to shop, and then you are saying like, okay, I am ready to buy this device, but I want you to check first. Yeah, I want you to check whether the device is working or not. So most of the time the seller will tell, okay, we are ready to check the device, but the condition is you have to pay first. So go to the counter and pay the amount for the device and then bring the slip. There is another counter for you to check. If there is a problem, of course we will replace with you, we will replace the new one with you, right? We will replace with new one. So now you see these kind of conditions are harmonious. Now I cannot go and argue with him, no, I'm not ready to pay because I'm afraid if I pay you might not do the checking. So you can clearly see the place that you are going. As long as you are holding the receipt, of course you are entitled to do the checking, and then it is also customarily accepted. Yeah, so this kind of harmoniously, whatever the conditions are there, it is allowed. Anyway, to go further, we are going into talk clearly what kind of conditions are valid, what kind of conditions are void. According to the view of majority of scholars, conditions put by the parties can either be valid or void. Okay, first of all, valid conditions. Let me give you, there are three categories of valid conditions. The first category is includes those conditions which confirms the effects already attributed by the Sharia to a certain contract. See, this is the first one, which means that the effects already attributed by the Sharia. All right, the good, very good example is actually what, if you are if the seller saying that I am ready to sell this TV to you, but you have to take it as a, you have to, I cannot deliver to you, you have to deliver by yourself. So now what do you see here? Is that what kind of difficulty you are seeing here? You see now the TV is there, right? You are coming to buy a TV, right? So now you paid the money, like let's say 2,000 ringgit, you paid the money for TV, and then the shop owner is actually handing over to you the TV which is worth of 2,000 ringgit, right? So now remember, let me take you back to purpose and effect. What is the purpose of what is the purpose in this contract? The purpose in this contract is very simple. The purpose is selling something, I mean exchanging the core value, right? Exchanging the core value is the purpose. So what is my core value? My core value to him is the 2,000 ringgit, and what is his core value to me is actually the TV. So now we are exchanging the TV for 2,000 ringgit, which means we fulfilled the purpose. Now, what is the effect in this contract? The effect in this contract is he has to hand over the TV to me so that I become the owner of the TV. So transferring the ownership. Transferring the ownership is what? Is becoming, transferring the ownership is becoming the effect of the contract. You got it? Now he has already given to me, the TV is already there, it now belong to me, the receipt built already. But now the problem here is he is not, the seller is not able to deliver the goods to your home. And he's saying that I don't have that facility, or maybe I don't have the, so now you see, now if there is a conditions before you, of course you conclude your contract, if there is a condition like this, these kind of conditions, seller can make these kind of conditions, because for the seller it is only the selling to you, not the delivering to you, because the product is already there, you can actually see the product, right? You see, now it's a different thing, we are doing with different thing. Now you cannot take the same contract that I was doing to you with a company that they're supposed to deliver the food to your home. You see, now because the company which is supposed to deliver the food to your home, their contract, their purpose and effect is actually delivery is a part of effect, right? I'm talking about, you know, the different company, the company is delivering the food or delivering the grocery or delivering anything to your home. they are the effect of that company, that dealing is actually what? Delivering to your home. But here we are simply talking about by buying an electric device, buying a TV in the shop. You are not actually buying in the online. Because when you are buying in the online, when you are buying something online, of course delivery is becoming part of effect. But when you are buying in a shop, you are going to a shopping mall and you are buying from the shop, uh, if he has that kind of feature, if he has that kind of facility of delivering to you, then of course you can accept it. Maybe you drop him and then you go to a different person and you tell him, okay, I'm here, I wanted to buy this TV, but my problem is I need delivery service from you. If he accept the delivery service, then you take it. Other than that, this delivery alone cannot become part of the effect. All right, you understand my point clearly? Understand? Because there are also some there are also some differences between different dealings. Today we are handling different kind of dealings today, because we have online travel, we have online dealings, we have food items that delivering to our home, right? There are pizza deliveries, right? There are food, there are so many others deliveries as well. So these are the different things, and now I'm talking about the different thing. Yeah, all right. So this is the first category. Yeah, example: conditions in a contract sale stipulating that object of sale to be delivered by the buyer is valid. The seller may insist that he shall keep the sold item until total payment is made. See, this is also another kind of example, very good example as well. So you wanted to buy an iPhone, and you the price is 3,000 ringgit and you paid only 2,000 ringgit, and then the seller may insist that he still keep the sold item. He already sold to you for 3,000, but you didn't pay him completely. You paid him only 2,000, right? So now you cannot say that I have concluded the contract, you're supposed to give me you're supposed to give me the product. He cannot give you the product. He can actually make a condition that I will not give you the product until you pay the remaining 1,000 ringgit, which is completely 3,000 ringgit, but you only paid 2,000 ringgit, right? See, this is all coming together. This is all valid conditions, all right? uh, uh, or requiring the purchaser a down payment in return for the stated delay in the payment of the price of the goods. So you want to buy something, you want to book something, if the seller asking you have better you book the product before it being sold out. In order to book the product, you pay 100 ringgit first, and then the remaining money you come on that day, particular day when the product arrives. On that day you pay the remaining amount of the product, then you take out your items. I will be deducting the amount that you are paying today, right? These are the conditions. Of course it is possible to have it. These conditions do not change the effect of sale contract and do not impose additional obligations. It is not actually imposing any additional obligations on either of the contracting parties, not to you, not to me. So these are the conditions are valid. This is the first category. Let me go to the second category. Refers to those conditions which agree with the effect and purpose of a contract to which they are added. For example, the seller may require pledge or a guarantor if the buyer who wants to pay the price later. You see now, you and me, we are actually doing a dealing. I want to buy a phone from you, and then I'm concluding the contract by saying that, okay, I'm buying this phone for 3,000 ringgit, but I have concluded the contract, but I don't have the money right now. So I am requesting from you delay late payment, right? So most of the time, this is what we are actually doing with the most of the banks, most of the, especially if you are paying a phone on monthly basement, a monthly installment. I think there are so many payment that we are doing on monthly basis. So these kind of transaction will come under this. Meaning to say that the transaction has been done the purpose and effect has been done, because you see the payment can be made later. Still it is actually contrary, even though you didn't pay completely. The payment can be made late. Without paying also you can actually conclude the contract. But here the seller wants to add another condition, which is actually addition to the contract, sorry, in addition to the effect of the contract. He wants to say that, okay, I will sell this phone to you on monthly basis, but one condition, you should bring a guarantor. Why I need guarantor? If in case you are not paying me, because I'm giving you my product, I need a guarantor. If in case you are not paying, I will collect the money from the guarantor. On this basis, today if you are applying for loan or whatsoever, right, they will be asking a guarantor, whether it is your parents or your brothers, siblings, or somebody, uncles, whoever related to you, is a kind of guarantor that they need. So this is the example for the second category. The last category of valid transaction, valid conditions, is the which includes those conditions which are customarily accepted. Remember, this is what we are talking about: the culture, the custom of your culture, my culture, or somebody's culture in their own country. It could be different. For example, the purchaser may require certain services according to customs. A seller may provide while concluding a contract of sale, like a guarantee period, during which the sold item would be repaired, right? See, this is what we call a guarantee period. It is also could be different to product. If you are buying a second hand phone, they will be saying there is a shop guarantee. There's a shop guarantee, shop warranty is available for 2 months or 1 month, right? If you are buying an international product, which is actually a new product, then they will be saying, okay, this phone has a 2 years minimum warranty, this refrigerator has 5 years minimum guarantee or warranty, this car has a 5 years minimum guarantee on the engine, and then 10 years guarantee on the body, or maybe the other way around, right? So now these are the examples. There are so many other examples. This is all customarily accepted. Yeah. So this kind of conditions always there. You can actually say, okay, I'm ready to buy this product, but I need the guarantee from you. Or can you give me the guarantee? I'm ready to buy the laptop from you. Okay, he will be saying, okay, 6 months or 1 year or 2 year, right? These are the conditions are valid. According to Hanafi, these kind of conditions is according to the istihsan. I think if you remember when we talked about the usul al-fiqh, we talked about the secondary sources, and there where you saw that there was a istihsan, juristic preference. According to Shafi and Maliki, a condition of guarantee period as a matter of principle to enable the purchaser to use it at least for a reasonable period of time. They go further, they say, yeah, this is the matter of principle to enable the purchaser, because without the guarantee you will not be, because you see, we know the product, like for example vegetables, you are buying vegetables, you don't need guarantee for the vegetables. So I'm buying this tomato, and then you ask the vegetable seller, how long you have guarantee, can I keep these vegetables, can I keep the tomato? No, there is no such thing for that, because you already know, everybody know what tomato can do, what rice can do, right? But here we are talking about something that you don't know what is inside, right? For example, you are not allowed to open and see what is inside the refrigerator, what is inside the phone, what is inside the laptop, right? So it is always closed by professionals. Expertise only can open and check. So you don't know about inside. How you need a kind of guarantee that I'm buying a product, but if there is anything faulty, if there is anything, any kind of mistakes, you should bear the responsibility, not me. So this is a kind of requirement. So that's why, according to Shafi and Maliki, they say it's a matter of principle. Okay, let's talk about the second the second part of the conditions. I mean, after we finished the valid conditions, now these are the conditions we discussed so far are the good conditions that you can actually make. So now, what are the conditions that you cannot, you should not make? These are the conditions we call void conditions. Yeah, are those conditions that may favor one of the parties at the expense of another. Right. So as I told you, remember the transaction we are talking. It is, of course, as Sharia implement the maslaha. So that Sharia wants to exchange the core value and also based on the mutual consent. But if the conditions that may favor one of the parties at the expense of another, then the conditions is not the valid condition, is a void condition. This is not allowed. That certain contract may compromise two agreements, one of which is a condition for another. For example, a person is not allowed to sell an item on the condition that the purchaser sell him something else to replace it, right? So this is what, for example, you see, I will sell my house to you, but you should let me stay in the house, right? And then why should I buy the house from you? Okay, maybe the thing that he wanted to buy the house and then he wanted to rent it to someone, and then I told him saying, okay, I'm ready to sell my house to you, but you should take me as your tenant. So this is kind of conditions you should not make, is a void condition. But if both of them agree with it, it's a different story. But this condition itself, the void condition. Or maybe I say, okay, I want to sell my I'm ready. For example, you go to a second-hand shop. I think usually this thing happen. Okay, I'm ready to sell this product, but you should sell what you are having right now. Whether it's a handphone or your watch or your spec or your, any other electric devices whatsoever. So these are the conditions you cannot actually make, these kind of conditions. Also, or buy some other articles, seller or purchaser, or rents him the article sold, like I told you, lessee or lesser, or lends him either its price or some other sum, some other sum, lender or borrower, or when a loan is given on the condition that borrower should buy a certain item from the lender, or asking the mudarib to pay certain guaranteed amount monthly, sahibul mudarib. So these are the conditions. You see, these things happens if you contemplate, certain transactions nowadays are happening. They said, okay, this see, now if you concentrate, I think you will see what I am saying. It's quite tricky that I'm going to tell you. Look around. If you see any discount, look around. If someone comes and tell you that, okay, this service is at discount price, then you will be saying, wow, mashallah, that this service usually, this kind of massage, for example, it cost 100 ringgit, but now it costs only 10 ringgit. So how it is possible, right? You must be surprised. And then they will be saying terms and condition apply, right? If you go to any place, for example, they say today is the extravaganza, today is the day that we are actually giving away so many things. The phone which is worth of 500, today we are giving for 100 ringgit. Then you will be surprised to see, wow, how it become 500 become 100. So what is it happening? Then you will be saying terms and condition apply. So if you look into terms and condition apply, most of the time it's a void conditions. If you know what are they talking, they said, okay, it is free, or it is at this price only if you buy certain items like this. So this item is at the discount price, but you should buy from us at least 50 ringgit or 100 ringgit on this. Sometimes, they give you a voucher. They give you, this is one I think you know better. They give you a voucher all the time. And then they said, okay, this voucher is 30%, 40%, 60% is offer. You will be surprised to keep the voucher, but they will be mentioning there, this voucher is non-refundable. This voucher is not possible that you give the voucher and take the money. You should buy certain things in order to enjoy this voucher. right? So you will see so many places these kind of conditions are there, so many places they are here. So I hope you understand more. And I always, I would love to talk about, these kind of things, just only because I want you to bring some practical examples that you are going through. That is the only reason I would love to, because I just want to relate myself to you when I'm giving you these fiqh al-muamalat. I want you to come up with the current, the modern practices that you are doing. If you can actually bring some examples like this in your writing, in your test, in your quiz, or in your assessment assignment, I will be more happy to see that. That is the only reason, this is the only outcome that I always expect. So for those, remember, whoever brings this kind of modern, recent and current practices, current examples, definitely you will be getting A in your subject. So do not expect A only, by memorizing the slides, and then you come up with the answer sheet, and then you get the full mark. Do not just do only that part. Okay, okay, you just bring some contemporary modern practices and examples and try to relate yourself to that. I think that one will help you to become the master of the subject rather than getting A in the subject. Okay, which one is more important, getting A in subject or becoming the master in the subject? Huh? Okay, many of you still say getting A is more important, becoming the masters. Yeah. Okay, I can read your mind. All right. So okay, so I think that is the thing. Such conditions are null and void whether they imposed by the seller or the buyer. However, the contract remains valid while void conditions are ignored. So these kind of conditions are there, which we call it void conditions. But still, if you take those void condition away, right, if you ignore those void conditions, then I think if you ignore those void conditions, I think you will be you can still do you can still accept the contract. There is nothing wrong in the contract. So you see, I just opened just now the slide. You can see void conditions, which means that may favor one of the parties at the expense of another, right? Thus, it is not allowed that a certain contract may comprise two agreements in one. All right. For example, it is not allowed to sell an item on the condition that the purchaser sells him something else to replace it, or buys some other articles, or rents him the article sold, or lends him either his price or some other sum, or when a loan is given on the condition that the borrower should buy a certain item from the lender, or asking the mudarib to pay a certain guaranteed amount monthly. You see, this is also something I wanted to tell you. Just now I gave you some current examples of voucher and massage and so many other discounts, rates and all, right? Other than this, if I have to come deeply, if I have to discuss with you with regard to the business dealing, the trading that they are doing, there are so many void conditions they are making. I'm telling you. For example, if someone is becoming the partner of of a business, they will be saying, okay, I'm ready to, I give you my money and you put your effort, and we can actually become the partner. But the real partner is, what, the real partner is who's supposed to, because the one who put money, he's supposed to take care of the losses. When it comes to profit, he will be sharing the profit to the person who he gave the money to do the business. But when it comes to when it comes to loss, he's supposed to take care of the loss. That is what we call sahibul mal. But if he brings so many other conditions other than the valid conditions, then those conditions are void. As I told you, all these things are actually void conditions. But if you can simply take away those void conditions, then still the contract can be concluded. However, the contract remain valid, the contracts remain valid while void conditions are ignored. Yeah, I think that's all for today. I hope you understood, and